Good evening. Welcome again to our live Q&A with myself, Advocate Mohammed Abduroaf. And today we're dealing with a few general family law legal questions. I see this one on child maintenance, another regarding consent for a minor child to attend a certain school, and one regarding a minor child who whose surname should a minor child have? Okay, that's question number two. Okay, anyway, the way it works, you're welcome to post questions live via the Advocate Mohammed Abdullah Facebook page or make use of those icons below. The popular one, it seems to be people register questions, and I see the questions, I post it onto the document which you see in front of you, and I deal with that question. And obviously, we notify you via email before dealing with that question online. And obviously, if you are busy and you do not have time to come online and watch these videos live, you're welcome to watch the video a day later or 2 days later, and be informed about what your rights are and what you can or cannot do. And wonderful. Let's start today's webinar. Thank you for watching again. Today's question, the first question is: I have a 5-year-old child born out of wedlock. The father is married and has 3 children with his wife. I now want to claim child maintenance for my daughter. I relocated from Cape Town to Durban. The father lives in Cape Town. Where do I begin? Okay, a not unusual scenario where a child gets born out of wedlock and the father has another family. Now, in terms of South African law, there is no preference given to one child over another child, or there is also no further preference given to a child born within wedlock and a child born out of wedlock when it comes to child maintenance. A father has the same obligation and same duty to maintain both his children, all his children, born within wedlock or outside wedlock, and the same with the mother as well. So, in dealing with a scenario like this, obviously all children are different, their needs are different. Therefore, if a father has a child, let's say, within wedlock, and that specific child is in grade 10, of course, there's school fees, there's certain expenditure which a child may have. Obviously, that child will cost more than the child who is 2 years old, obviously. But however, if both kids are the same age, then the father cannot say, but this child must go to expensive school because I'm married to my wife, and the other child, unfortunately, they're not married. That child must go to a cheaper school. He'll pay less maintenance to that child. The law doesn't work that way. Obviously, fairness, equity, etc. Everything has to be considered in determining what is fair under the circumstances. We want justice to prevail. So that's the law, and the bottom line is whether or not a child is born within wedlock or outside of wedlock, whether or not you have a child born within wedlock and another child born outside of wedlock, you still have the same obligation. Children are children, your obligations is your obligation. So that is it. The law in the past, for example, stipulated years ago that children born outside of wedlock, the paternal grandparents of that specific child have no legal obligation to maintain that child. Luckily, the Peterson versus Peterson versus a maintenance officer came into operation, and that specific court, the Western Cape High Court, ordered. You see, there's no difference, whether or not the child is born within wedlock or outside of wedlock. The grandparents, paternal and maternal grandparents, have the same legal obligation to maintain the minor child, irrespective of the status or the birthing status of the minor child. So that's fine. I think we sort that issue out. So when I see the word wedlock or outside of wedlock, when it comes to child maintenance issues, I do not necessarily apply different legal principles. You will see in question 2, when it comes to a surname change or the surname of a minor child, then obviously wedlock or outside of wedlock may play a role, or it would play a role under the circumstances. But generally, it would not. Even when it comes to issue concerning care and contact rights, the court looks at what is in the minor child's best interest. So if a father has a minor child born outside of wedlock, it does not give him less rights to the minor child. He has the same rights to the minor child as if he was married to the mother. And the minor child has the same rights towards the parents, whether or not the minor child was born within wedlock or outside of wedlock. I think we resolved that issue now quite at length. So, what is my advice to the specific question? Question number one: child is 5 years old. The mother relocated to a different province, to Durban. The father still lives in Cape Town. Where does she begin? Okay, Maintenance 101. Okay, there has been some amendments to the Maintenance Act. And obviously, we all know now that you can apply for maintenance where you live and where you work. So that's fine. So I presume the mother is maybe working now in Durban, which is possible, or alternatively, she's living there, and the minor child would be with her. So the maintenance court the mother would have to approach would not be the Cape Town maintenance court where the father stays. It would be the maintenance court in Durban. Very important to note. You approach the maintenance court where you live and the child lives. You don't approach the maintenance court where the respondent, the party that has to pay maintenance, lives. So if the child lives with the father and the father would like to claim maintenance from the mother and the mother lives in a different province, the father should apply to the maintenance court where he lives or where he works. So that's very important. So my advice to the specific questioner would be approach the maintenance court in Durban, the local magistrate's court. There should be a maintenance court there, and lay the complaint for maintenance there. What would happen is they would ask you to complete a Form A. Basically, you stipulate what your income, your expenditure, the needs of the child, how much you want to claim, some details of the father, your details. If you do not have the details of the father, there are maintenance investigators who can assist in that specific regard. They can do some investigations and obtain that specific details. But in today's day and age, in this day and age, it is very easy to find somebody's details. Everybody has a cell phone. You can do those RICA and some credit checks. People are available. People are on Facebook. People got cell phones, WhatsApps. It's easy to find someone nowadays, unless a person went to a total different country, where they speak a different language, where they do not speak English, and it can become a bit harder. But nonetheless, if someone lives in the same country like you, the possibility of not finding that person can be very hard. Everyone has a cell phone. A person who's unemployed, someone that's on the streets, sad, but you see people with cell phones as well. So that's how it is. Approach a maintenance court, make a complaint. They will notify the father to come to the Durban maintenance court. Very important to note. The father in this specific scenario would have to come to the Durban maintenance court for the maintenance inquiry. Long story short, they'll do a bit of an investigation. They'll ask a bit of questions to the father, to the mother. They'll try to resolve the matter. The father would obviously have to first confirm paternity. If he disputes paternity, unfortunately, the matter would have to be postponed for a paternity test. If those results comes negative, matter comes to an end. If those results are positive, the court can make a maintenance order backdated, basically. So since the date the child was born, the court can make such an order. So delaying the matter with a paternity test, yes, it could potentially delay the matter, but it does not mean you will pay less maintenance overall. You still owe the money. And if the matter cannot be resolved at the maintenance officer's inquiry, the matter would obviously have to run trial, whereby the mother would go on the witness stand. She will, under oath, put up her hand and swear in, and she will outline what her income is. If she has an income, if she does not have an income, she will have to explain what effort she's making to obtain an income, and so on, whatever the case may be. And also the expenditure for herself and for the minor child. Was reasonable? She'll come with spreadsheets, proof of expenditure, receipts, and so on, and explain to the court, I earn so much money, the child costs so much money, these are expenditure, I require so much from the father, this is what I know from the father, etc. So that inquiry will go along where she is concerned. Then the father will come or his attorney will challenge the mother's expenditure. He might say, no, how can the child require 2,000 rand for internet per month? Obviously, the child is only 5 years old. How can you put 2,000 rand for that? Why do you require a super fast line of a gigabit speed? I think maybe a 20 meg line would have been enough. And obviously, the mother is also using it. Why should that 2,000 rand be allocated to internet speed for the minor child? And the father would have to contribute towards that. So he might dispute that. He might dispute some groceries, etc. But nonetheless, he is welcome to dispute it. I have no issue with that. I believe if you are involved in a maintenance inquiry, it's very important that fairness prevails. Therefore, if the father needs to challenge anything, let him challenge it. It will be resolved. The court will ultimately make a decision. And same way with the mother. If the mother wants to challenge the father's expenditure, she's welcome to do so. Okay, so the mother is now done. She's done testifying. She's been cross-examined. They've she conceded to a few points. She said, "Yeah, you know what? I think gifts, gifts of 200 rand or 500 rand per month for friends is a bit too much. Outings for 2,000 rand per month is a bit too much." So she brought it down, and a claim for argument's sake, 5,000 rand per month came down to maybe 4,000 rand per month. School fees, maybe she's not been paying school fees, but she stipulated amount for school fees. Petrol, she mentioned petrol, but she doesn't have a car. She uses Uber, whatever the case may be. The father again, he will come onto the onto the witness stand. The father will come on the witness stand, and he will testify what he earns, his expenditure, his 3 children, his wife, how they married, what does she contribute, and ultimately what he can afford. And he will have to outline exactly what he spends for all his children, his 3 children with his current wife. And the mother's lawyer will cross-examine him, or the maintenance officer, depending upon who is involved in this matter. Just to pause there, if you do not have an attorney, generally the maintenance officer would represent you, or not represent you, but assist you or be involved in the inquiry and ask questions, either to you or to the other party. But a proper maintenance inquiry would be where the maintenance officer sits in and the lawyers can cross-examine the witnesses, but the maintenance officer will always be there to give her his or her input into the matter. That's a proper inquiry. But nonetheless, that has taken place. After that, the parties will argue, and then the magistrate will make a decision as to what he or she believes is a reasonable amount of maintenance. So that sums up the maintenance process for question number 1. I see we have a question as well, a live question on Facebook Live. I shall deal with that after I deal with the third question. You are welcome to pose any further questions on Facebook Live. I'll be happy to answer that for you. Let us move to question number 2. I am 7 months pregnant. Can my child only have my surname? Or must the child have the father's surname? Okay, I will presume this is a scenario where the child was born outside of wedlock. Very important to note. So in terms of the Births and Death Registration Act, if a child is born outside of wedlock, then the child can only be registered in the surname of the mother. Very important to note that. The only exception to that is if the mother obviously agrees to it and the father consents to that. It's very important because the mother can say, my child was born and that gentleman over there, he is the father of the child. But in the Department of Home Affairs might ask, but he's not here, he's not consenting to it, he's not saying he's the father, he's not acknowledging he's the father. You can't mention any guy's name, anybody's surname and say that person is the father of the minor child. That would also not be right. So your surname is A, and now, I like that guy's surname, his surname is B. Randomly, you say, that guy is the father of the child. It does not work that. He must come to the table. If the child is, if you are, of course, married to the father of the child, that's something else. The child can have the father's surname, a double battle surname, whatever the case may be. So I hope that answers your question. Or maybe to go take it a bit further, a child will have to be registered at the Department of Home Affairs. That makes logical sense. So whatever surname is given, you can't block it. The father cannot say, I want my surname for the minor child. If you don't register this child, sorry. So the child is registered, done. If the father has a problem with that afterwards, with the surname of a child born out of wedlock, and he would like to change the surname to his surname, he can make an application to the Director General of Home Affairs, obviously, and give very good reasons why he wants a child to have his surname. But that's something for another day, but it is possible. I hope that answers your question. Something very interesting, something which I deal with now and again. Generally happens where a child is born outside of wedlock. The child has a father's surname, but the father goes missing. The child now goes to primary school, grade R. Now, problem we have is the mother's surname is A, and the child's surname is B. but the father is not involved in the child's life. He doesn't pay child support. He does not see the child. It becomes problematic because everyone asks the child, John, your surname is B, but your mommy's surname is A. What happened there? Where's your dad? Or the mother might have already married, stuff like that. And now there's three surnames in this house: mother's surnames, new husband's surname, and the child's surname. Better to have it all in one. But that's a topic for another day, but they can all be looked at, or you can learn something from that. Just Google the Births and Death Registration Act, and there's quite a lot of data regarding that. A child obtaining the surname of the stepfather also. That was something interesting which I dealt with in court some time back. The third question: the father of my child does not want to consent to a school change for my son. He is currently in grade 8 and wants to attend a different school. What can I do if the new school insists on the father giving consent? Typical scenario, this time of the year, I always deal with this in the High Court. It's something which comes to my desk a lot. School consent. Sometimes it goes to court, sometimes it can get resolved via correspondence between the lawyers, or people must sit on the same table together and resolve it. So we all know, as schools these days, depending on the school also, but generally, they require both parents to consent for the minor child enrollment into their specific school. There could be very good reasons for that. Number one would be, of course, legally, because the guardians must consent. The child is now attending a school, being cared for by the school, under the school's custody. Anything happens to the child at the school, the parents will have to blame someone. But if the father said, I did not consent to the school, how can you have taken on my child? I have not consented. So the schools want to avoid problems from happening in the future. Therefore, they want consent from both parents. But some schools, they understand the plight of mothers, single mothers, and I respect those schools. And they enroll minor children without the consent of the father. Maybe because the mother explains to them the father is missing, the child's life is nowhere to be found. But if the father is somewhere to be found, he must be consented on that. But nonetheless, here in this case, the father knows about the child wanting to attend a new school, but the father refuses that. Unfortunately, you would have to obtain a court order, and a court order would basically stipulate that the father's consent is dispensed with, and the mother can enroll the child to the specific school without the father's consent. But that could cause other issues. The school might say, who is responsible for the school fees? I want both mom and dad to sign for this. So can become a bit challenging, but at the end of the day is a court can override the consent requirement. The school cannot now say, but we require the consent. The school is basically indemnified for that legal requirement. So if you have any other questions, you are welcome to pose, and I'll be happy to answer that. I have a live question. Let me just copy and paste this into our question. Okay, is it? That it is. So that's our Facebook question live. Thank you very much for that. I enjoy it when people interact live with us, and that's our whole purpose. And if I do not answer your question, you're welcome to keep on typing live questioner, and I will keep an eye on that. So the question goes as follows: my husband and I are in a heated custody battle, but not yet divorced. So they are married. I need to register our son for the upcoming school year, but needs my husband to pay for the registration fee. There is no maintenance order in place. How do I approach for interim maintenance, and who do you advise that I follow this route? Okay. There are few options you have. Obviously, we're dealing now with money issues. If you are in the process of getting divorced, there is, of course, what they call a Rule 43 in the High Court, or Rule 58 in the Magistrates Court, dealing with interim maintenance. That procedure can take about not quite some time. It's quite quick, but not immediate. Not immediate, but about a month or two. So that's the one option you can follow. I would advise you to do that as soon as possible. Alternatively, obtain the services of an attorney to contact the father and to explain to the father, these are the routes which we are going to follow. The other potential route is, of course, the maintenance court. That's always available for you. can also be a bit long. The other potential route, which we obviously have to weigh and consider depending upon the facts of the matter, would be the domestic violence court for emergency monetary relief. The father is refusing um, financial assistance, economical abuse, and so on. So it depends on. I do not want to easily advise someone to follow that route because there's a lot of factors which I have to consider and look at. But the bottom line is, unfortunate, it's now at the brink, and these things you'd prefer to be resolved quite way in advance. If it cannot be done for this specific term, maybe the next one, maybe take out the loan, pay the registration fee. When the matter is finalized in the maintenance court can ask the father or order the father to pay you back that specific amount. You deal with that, or in your Rule 43 application in the High Court, or in the 58 application in the divorce court, in the magistrate's court, they can deal with that as well. My advice to you is obviously if it's best for the minor child, have the minor child enrolled, let the child attend the school, take out the loan if you have to, but sort out the legal issue afterwards. I would not want the minor child not to be enrolled in a better school for financial reasons if there could be some other ways of having resolved it, but ultimately resolving it in a legal fashion, or in some way or other have his father pay the money towards the registration of the minor child into a school. The challenge we have with registration or asking someone to pay it, the dispute might not necessarily be specifically the issue concerning affordability. The issue is sometimes the issue regarding the school itself. Is a party willing to consent or want the minor child to change schools? But nonetheless, I see a further comment from a live questioner. No, of course we don't mind. Let me deal with this part as well. Okay, I'll make this question 1 and question 2. Okay, the formatting did not come out so nice. Question 2. If you don't mind, of course I don't mind. My son is being kept at a youth care center for the duration of the social worker's investigation, which has been drawn out for many months over the 90-day limit, and the court is allowing this regardless, which I believe is against the law. How can this be resolved? Very difficult one, because the moment a child is in a youth care center, obviously social development and social workers, Department of Social Welfare, and all those people come on board. So does it mean if they, in their view, believe it's best for the minor child to be kept there, and the 90-day period obviously has now expired, does it automatically mean now the child has to be released, into the, for lack of a better term, into the wild and so on? I think they will be obviously neglecting what they are supposed to do. So my advice to you obviously is to find out exactly what the problem is. Complain. I believe people are entitled to complain. Make some noise and find out what is happening here. I have a right to speedy legal resolution of legal matters to deal with a minor child, and speak to the magistrate as well, because they have to follow the law and so on. It is COVID-19. There are various reasons why these things specifically happens. I do not know what your specific reasons are. You might give me a reason, but they might have a different reason. Make some noise and try to resolve this matter as soon as possible. And worst case, if you have to go to the High Court, go to the High Court and say, this is unfair, improper, something should happen. So I hope it assists you. I do not have enough information, obviously, to give you a proper answer. It's like I'll be guessing, but at the same time, I would want you to start investigating, speaking to people, find out exactly what's happening so this matter can be resolved and expedited. If the child would be neglected by leaving the youth care center, of course, we do not want that to happen. But at the same time, we do not want the child to remain in a youth care center indefinitely if it's not in the child's best interest. So I hope that answers your question, and I hope you resolve that matter as soon as possible. Okay, I see no further live questions. I think we can end the video now. Thank you very much for your time. I do appreciate it, and I shall see you again online either tomorrow, depending upon how the wind blows, alternatively next week. Have a lovely day.